Next on the docket, we look at the highest court in the land. The Supreme Court is set to hand down decisions tomorrow, and it could rule on cases involving same-sex marriage and Obamacare. The Obamacare ruling hinges on the subsidies that people are getting from federal exchanges. If that's deemed illegal, 6 million people in 34 states would be impacted, and there are some saying the whole law could be in jeopardy. The gay marriage ruling will answer two questions. Can states ban it? And can states refuse to recognize a same-sex marriage performed legally in a different state? Right now, same-sex marriage is legal in 37 different states. And Mark, we'll start with you as the guy who's argued before the highest court in the land. What are the options for the court on same-sex marriage and how it might rule?
Well, as you indicated at the outset, it could be under an equal protection rubric, which is the recognition question of same-sex marriages by states that don't currently permit it. And the big enchilada, the one the gay rights advocates really want, is a substantive due process ruling saying that under the Fifth Amendment you have not a procedural right to marry, but a right guaranteed by virtue of life, liberty, and property to marry whomever you want.
So it could essentially legalize same-sex marriage across the United States, or it could continue to leave it up to individual states?
Well, I think it's going to legalize it across the United States one way or the other. The interesting question for legal geeks is how they get there, which rationale, or a combination of both. And probably what I suspect will happen, it'll be a combination of both, whereby one rationale won't garner necessarily 5 or 6 votes, but when you put them together, they'll amount to the same thing. And
if the court legalizes same-sex marriage across the country, do opponents in those states where it's illegal have any options or any ways around it? Would these religious freedom laws we've heard be essentially an alternative to outlawing same-sex marriage?
Well, it's an interesting question as to whether they would be able to bring some kind of claim, a RFRA, a Religious Freedom Restoration Act, or its analog, or say that their First Amendment rights are being trampled, their First Amendment religious rights. The problem is, you know, letting somebody else marry doesn't really destroy the sanctity or undermine the sanctity of your own marriage, so I don't see that.
Although it will allow them to make the same arguments they made in Hobby Lobby, that you can't be compelled to do things that are against your fundamental beliefs.
Well, that was a nice segue. I mean, you have a future in journalism, given what we're about to talk about next.
So let me go around the table. Jim, what do you think the court's going to rule on this?
I agree. I think they're going to legalize it. I think that at least what is being said is Justice Kennedy will be the swing vote, and I do think that it will become legalized and that the states will not be permitted to ban it, and that people will be able to get benefits moving from one state to another.
Mayo?
I agree. I think you're going to end up in a situation where you've got to give full faith and credit, and when you get married in one state, it has to be honored in another. Just like a driver's license.
Well, see, if I had to engage in speculation, which is what we do when we try to read tea leaves, I think that Kennedy will embrace the rationale that Jimmy just said. He has a penchant for human dignity type language, and I think he'll root the decision in saying there's a fundamental right to marry. I think Roberts will go Mayo's way under a narrower ground, full faith and credit, a recognition route, but they'll both come out in the majority, in my view, just using different rationales.
All right, let's move on to Obamacare. And this one seems a little more nuanced because it seems to be, instead of about the idea or the concept, it seems to be about very specific language within the Obamacare law.
Well, that's what it should be about, but the president, unfortunately, is now going around attacking the Supreme Court and trying to really, by definition, all of these cases, these two cases, are intensely politicized, but this is really unbecoming in my view.
Well, walk us through what the court could do with Obamacare.
Well, I think you framed it accurately when we started. It's a narrow question of statutory interpretation. The language of the statute says the exchanges have to be state established. Treasury, which is charged with implementing this, and the tax breaks promulgated a regulation that says no, notwithstanding the statutory language, what it means is we'll subsidize federally we'll give the subsidies to federally funded exchanges as well. Question is whether that's a permissible interpretation of the plain language and whether it deserves any deference because of it's promulgated by the agency that's administering it, and in my view the answer is no. It's not a reasonable interpretation, and they don't have any particular expertise or competence in enforcing it. So I think if you're going to apply the law, I think it should be stricken.
Jim?
The language is as clear as it gets, and you've heard excuses from it being a drafting error to being misconstrued. The language doesn't get any clearer. There was some scuttlebutt several months ago that it was thrown in there for a specific purpose, hopefully that it would be overlooked. The language is what it is, and the bottom line is it cannot
And
survive.
there's
But
conflicting
the
indications in the legislative history which illustrates the perils of relying on it. Some people say it was a Scrivener's error, it was an accident. I've read reports that say no, it was deliberately placed in there to coerce or
That's
compel states to buy in. The bottom line is when you read the statute, the language says what the language says. Congress should fix it. We have a gridlock Congress now. Obama knows it won't be fixed, not in a way that he likes. And so here we are.
But elsewhere in the law, the federal government and the state are interchangeable in terms of the language. And,
No.
and the argument is, or one of the arguments I've heard, is that that should apply to that clause that's being contested.
I don't. That is a dubious canon of statutory
I
construction.
think
Mayo?
that happens where you're suggesting that either the state or the federal government has established the actual mechanism. But where there is no mechanism, it's pretty expressly stated that it has to either be the state or the federal government. You could perhaps argue that the intent was different, but again, when you go back to what the statutory construction was, it's going to have a problem. But when you really look at the political consequences at the end, it's going to put people in a very difficult situation in the states that don't have the mechanism, because people are beginning to become accustomed to having this health care, and if you take that away, it's going to have additional consequences.
Well, they could opt in, though. The states could still opt
Well, the
in.
states
But they
will
don't
have the
need to
pressure
strike
to
it down.
actually
They
do
could
that,
say
though.
this is what
Correct.
it means.
They're just going to say
Right.
that the interpretation is not valid, and you either comply. Look, this
Right.
is all educated guessing.
Mayo mentioned the intent of the people who wrote the law, and there's been a lot of interviews with members of the Senate and other members of Congress who were involved in drafting the law. And it seems like the overwhelming intent of the people who wrote the law was for this to apply even towards a federal or states. It doesn't seem to matter, whereas the decision that the Supreme Court is making is hinging on the specific words. Should the intent of the lawmakers play a role in this?
To a certain extent, yes, but if you so intended, you would have so written. And I think the intent was in the end for it to apply to everybody. But if, as Mark says, if it was a way to force states to opt in, maybe your intent was, well, we'll force them to opt in and we'll achieve the goal, but you still wrote what you wrote.
let me
There's a
explore
schism on the court about the validity of looking to putative legislative intent. We know that Scalia and Thomas will never look to it. We know that Breyer and Ginsburg and Sotomayor will look to it. The problem here is that the intent is very, very murky. It's not clear one way or the other, and I think they're going to be, really getting into really tough waters if they're trying to discern what the intent is. The easiest way is just to read the text of the statute, at least in this case.
But if the intent, and even some Republicans who have been involved in drafting the law say our intent wasn't the way that
Then
this
fix it.
lawsuit...
Fix it.
But obviously that's sort of
Well, but
stuck right
that's
now.
really not institutionally. You shouldn't be making decisions based on the fact that we're gridlocked, which is, of course,
But
the
who
reality.
here hasn't written a letter or written something where it doesn't come out exactly the way you intended it
And
to?
the courts are always in a situation where they start to tell you what was intended. So they find a means to get where they want to go.
Some do. I mean, the
Quite
Supreme
often.
Court. This is not an abstract question. I mean, this is an ideological divide between the two wings of the court: textualism, literalism, versus some more
Amorphous
amorphous
intent.
intent.
Mark, very quickly, if Obamacare is upheld by the Supreme Court, is this the end of the challenges for it, or are there other... Can you see other avenues for challenge?
You'd have to ask a politician about
Yeah.
that. He's going to
I'm
be
asking a lawyer.
he's going to be out of there. By the time no challenge probably will get to the Supreme Court before Obama gets out of there. I'm not aware of one of this magnitude that would get there that quickly. But the Republicans are going to take their shots at it, and then you can question whether that's wise or not. I don't know why the Supreme Court keeps taking these cases up, these political cases, because the more of them it takes up, the less credibility it has as an institution.
And we've gotten into that topic on this program before. All right, all eyes will be on the Supreme Court on Thursday, and if there's no ruling on Thursday on either of those cases, stay tuned for Monday, which would be the next available day for those rulings to come down. Up next, President Obama just announced new rules for paying ransom to terrorists. He's basically saying if families break the rules, the government will look the other way. But is that opening up a legal can of worms?